Gum has given her apologies because she's got a family emergency, if that's okay.
Councillor Clark, we are now live on YouTube.
Thank you. Right, good evening and welcome to this evening's Growth and Development Scrutiny Group. Can I welcome anybody that is watching live streaming on YouTube as well? I'm sure there are many thousands of you sitting there with your ears gripped to the screen. Anyway, I'm for those who may be watching, I'm Councillor Neil Clark, Chairman of this Scrutiny Group. And then we also have Councillor Brennan, who's the Vice Chairman, then Councillor Verdi. I'm just reading off the screen, or looking along the screen now. Councillor Verdi, Councillor Stockwood, Councillor Thomas, Councillor Phillips, Councillor Cotty, and Councillor Howitt. I think those are all the members of the group that are present. Okay, right, so item 1 is apologies for absence, please.
Chair, apologies for absence from Councillor Begum and Councillor Way, and Councillor Thomas is standing in as Councillor Way's reserve.
Thank you very much indeed. Item 2, do we have any declarations of interest, please? Either pecuniary or non-pecuniary. Nope. I'll take silence as no. So item 3, minutes of the meeting held on the 15th of July. Can we approve those as a correct record, please? Everyone in favour? Yep. Okay, thank you very much indeed. Right, so without further ado, we'll move on to item 4 then, which is the first of the two sort of main items on our agenda. We do have some officers and indeed councillors who will be speaking to this item as well. So the first item is regarding planning enforcement, and I expect this will be quite a detailed and comprehensive discussion, and you've got the papers before you. We did ask for councillors to submit, anybody who wished to make a submission, beforehand. And you may recall at the last full council meeting, Councillor Rod Jones did make comments regarding planning enforcement, and I did ask him if he would like to come and address this meeting. So he has made a submission prior to that, and I will be inviting him to speak after I've asked Mr. Pegram to make a presentation. I'll then ask Councillor Jones to just submit his comments, but I will ask him to limit it to just 5 minutes, and then we'll carry on the debate from there. So without further ado, I will now turn to Mr. Pegram, and would you like to present the report, please?
Thank you, Chairman. I am joined tonight by Nick Cox, one of my principal planning officers, who is responsible for managing the enforcement function, and obviously here to help with any questions that there may be. In terms of the submissions made by councillors, we'll try and pick up on the majority of those as we go through the discussion and the presentation. The intention is afterwards, though, we'll circulate that as effectively a question and answers paper and update it as necessary. So if I can share my screen with you and take you into the presentation. So the driving force behind the item this evening is the fact that we are currently developing an enforcement policy. We do have a code of practice currently, but that document is not formally adopted as such. So the policy would go through Cabinet and full council to eventually become an adopted document of the council, and therefore carry greater weight than the code of practice. So, Chairman, if I can just go through some of the most salient points. In terms of enforcement, the authority is responsible for enforcing a number of different regimes, not just planning. We do have a corporate enforcement policy that was adopted in March 2010. That was last revised in June 2017, and that acts as an umbrella policy which applies to the various different services and the enforcement regimes throughout the council. As you can see, highlighted in red is the planning and development control, or we actually call development control development management these days, but that's effectively covered under the umbrella policy. Generally, and the statement in that document is that the purpose of enforcement is to protect the public and individuals. So whether it be to do with environmental crime, building regulations, licensing or planning, the council obviously has a role to protect the public and individuals. On to planning, I think the important starting point for planning is that we only have, as a local planning authority, we only have control over development. If it's not development, it's not controlled by us as a local planning authority. And you can see there on the screen, I won't read it out, but you have the definition from section 55 of the Town and Country Planning Act of what is deemed as development. We do deal with some other related applications. So there's things like advertisement consents, special consents for listed buildings, demolition of buildings in conservation areas, and telecommunication masts, to mention just a few. One of the grey areas in planning is this one referred to as a material change of use. You can sometimes have a situation where a property is used for more than just a dwelling. In fact, I'm doing that this evening. Clearly, I'm working from home, but that's not necessarily a material change of use, and therefore sometimes we have to judge it by fact and degree. Main provisions are for planning enforcement are contained within Part 7 of the Town and Country Planning Act 1990, and importantly, Section 171A basically defines what is a breach of planning. So it's the carrying out of a development without the required planning permission or failing to comply with any condition or limitation subject to which planning permission has been granted. And again, it's important to reflect back that that only kicks in and applies if it is development. It is also important in planning terms to note that development that's carried out without permission is not illegal. It is unauthorised. It doesn't become an offence until such time as we've served an enforcement notice and someone has failed to comply with the requirements of that enforcement notice or another form of notice. There are some exceptions, including damage or demolition of a listed building, chopping down a protected tree, or displaying an advertisement without the relevant consent. Those items are illegal and we can prosecute or go through the magistrates' court taking action for those issues. Again, it's important to note that whilst the local planning authority has a statutory duty to determine planning applications, it's actually discretionary whether we take enforcement action or not. So it is a discretionary service. It's obviously one which the council is judged in terms of its reputation and effectiveness. Hence, we're here this evening to discuss this. And it's important also to note that we do not condone actions of developers or property owners who do not comply with planning legislation. However, the guidance is quite clear that we should not use the process punitively. So in that respect, if someone does something without planning permission and they seek to regularise it through a retrospective planning application, we shouldn't refuse that application purely because they've already carried out the development. The development has to be considered as if it hadn't taken place and on its merits. If it's unacceptable and permission is refused, then obviously further action could be taken to remove that development. So when we're starting to investigate an alleged breach of planning control, the first thing we need to do is establish, is it a breach of planning control? Again, I repeat, does it amount to development? If it's not development, it's not a breach of planning control. Was permission needed? As you're probably aware, there are lots of consents or lots of types of development that can be undertaken without the need for an application to the local planning authority. These are generally referred to as permitted development rights. Another one might be, has permission already been granted? We sometimes get calls from people who may not have been aware of an application. They may have moved into an area after the application was granted, and then when work starts on site, they ring us up and say that their neighbour's doing something. So one of the things that the officers will do is check, first and foremost, has permission already been granted for what's being developed? when we're investigating a breach and determining whether we can take action or need to take action, we have to establish the degree of harm. So it's not just enough that a breach has occurred. If we're going to take action and that action is going to be successful, we need to identify the harm that's occurred and what we're trying to remedy. One of the questions we might ask there is, would planning permission have been granted? If it's a development of maybe a small extension on a residential property, if permission would have been granted, we might decide that it's not expedient to take action. We will try to resolve the situation through discussions, and in fact we're encouraged to do that through the National Planning Practice Guidance and the NPPF. We should only really take formal action as a last resort when we've failed through all other channels. I like to think that there's some would measure the success of an enforcement service by the number of notices it's served. I would like to think that if we've got to the point where we have to serve a notice, we've probably failed to resolve the issue through negotiation and discussion. It's important to recognise that in some cases, breaches may be immune from action. The slide on the screen at the moment sets out what we call the immunity periods. So if we don't commence action within a certain timescale, then we can't take action against a breach. It doesn't mean that that development becomes lawful. It just means that it's immune from action. So it's, generally speaking, 4 years from the substantial completion of the development, in the case of operational development, 4 years for an unauthorised change of use of a building to a single dwelling house, and 10 years in any other case or in the case of a breach of a condition. There are some exceptions to the time limits which apply, particularly if the development has been deliberately concealed, and I'll come on to that again in a moment. So how do we tackle these breaches? There's a range of ways, and as I've said already, we are encouraged to try and deal with them through negotiation, discussion, and to only take formal action as a last resort. The NPPG advocates that action should be proportionate to the alleged breach. So again, if we have got a situation where we need to consider action, that action needs to be proportionate to the breach and the harm that is arising from that breach. As I've said again, it may not be expedient to take action in some circumstances. It might be a technical breach. It might be someone's done something in ignorance of the regulations. Yes, it's a technical breach, but there's no material harm, and it's not in the public interest to therefore pursue that particular breach. And therefore, we would close a case potentially on the basis of not expedient to take action. It's important in those circumstances to recognise, though, we do encourage the people to try and regularise the situation. For instance, it could prevent a sale of a property at some future date if they haven't got planning permission and their solicitors or the buyer solicitor picks up on it. So we will try and encourage, where possible, for people to regularise breaches. And the other opportunity that gives us is to put conditions on permissions which then mitigate the adverse impacts of that development. As I say, again, bottom line, formal action, we're not afraid to take formal action, but it is very much as a last resort. So before deciding whether we take formal action, we can use what's called a planning contravention notice. This is generally an information gathering tool that we can use, and we can ask pertinent questions about the activity, who owns the land, who is operating from the site, and that information is then used to determine what action we take and who we take action against. Interesting discussion we had the other day, because we were being encouraged to take action against some works that were taking place, but the person who was undertaking those works didn't own the land or didn't have a legal interest in the land. What it meant was, if we served an enforcement action, we'd probably be serving an enforcement action on somebody else, or possibly even the county council. So clearly we need to understand exactly who is responsible for the land. When we are, I should say it's also an offence not to reply to a planning contravention notice. So obviously if someone doesn't reply to a contravention notice, we can go through the magistrate's court for legal action. If we decide that formal action is appropriate, there's a number of tools available to us which have different benefits. Again, the action must be proportionate to the breach, and the appropriate tool can be used for the appropriate breach, obviously. So we have things called breach of condition notices, where there is no right of appeal, an enforcement notice, where there is a right of appeal. Little used, but we have used them, stop notices or temporary stop notices, a planning enforcement order or injunction. And I'll take you through each of those in a bit more detail. There's also section 215 notices that we use when land is untidy or affecting the amenity of an area. So an enforcement notice can be served where the breach of planning has occurred and it's expedient to do so. So again, it's back to those tests and applying the public interest tests. As I said, we have to serve the enforcement notice on someone who has an interest in the land. So it has to be someone who either owns the land or has a lease or a rental agreement to be able to serve that notice on them. One of the grounds for appeal can be that the notice has not been correctly served, i.e. it's not been served on the person who has the interest in the land. The notice has to identify the breach that has occurred, the harm that's arising from that breach, the steps that are required to remedy that breach, and the time for compliance with the steps. And I've got some case studies that just examples of those issues and what has to be included in an enforcement notice. The notice must specify the date on which it takes effect. It can't take effect immediately. It has to be a period of not less than 28 days from the date of the service of the notice. And during that period, the recipient of the notice can appeal to the planning inspector against the service of the notice. We then come on to the point where failure to comply with the notice is an offence. So that's the point at which legal action would be appropriate or could be appropriate. So I say there's a right of appeal against an enforcement notice. And as you can see, an appeal can be lodged on any one of those grounds. A, that planning permission should be granted. B, that the breach of control alleged has not occurred. There's not been a breach of planning control, i.e. it's permitted development or not development. Ground D, that the notice was served too late. So that could be back to those immunity periods that 4 years has elapsed. Ground E, not been properly served on everyone with an interest in the land. And we did have a case a little while ago where the recipient of the notice did indeed appeal because they were new owners of the properties. It was the developer who was effectively, arguably, responsible for the breach, but as they were the owners of the property, we had to take action against them and serve the notice on them. Ground F is that the steps required by the notice are excessive. So it could be, for instance, that we've asked for a structure to be removed, and they argue that perhaps by reducing its size or its height or its length or something could make it acceptable. And then last one is that the time for compliance is too short. So we might give a very short period of compliance time, which they feel is unreasonable. Breach of condition notice, again, this is quite a useful tool. Can be served where there appears to have been a breach of condition. Again, the notice must specify the steps that are required to comply with the condition. Again, the period for compliance has to be not less than 28 days, but the beauty of this tool is that this takes effect immediately that it's served. There is no right of appeal, and anyone failing to comply with that notice is then guilty of an offence. We do sometimes get into discussions with our solicitors because where it might be apparent initially that a breach of condition notice would be the appropriate tool, the solicitor may feel that no, in the circumstances, actually it's an enforcement notice that we need to serve, because it might be because of the requirements of the notice. It can't be done through a breach of condition notice. It needs to be done through an enforcement notice, for example. Temporary stop notices. This is, as it says, a very powerful tool. We can use these where there's a need to bring an activity to a halt immediately. I'll come on to an example where we've used one of these recently. Again, it's one that we have to use very carefully. It can prohibit a range of activities that are taking place either intermittently or seasonally. but we have to make sure that it's in the public interest to serve a notice, and we have to carry out what's called a cost-benefit analysis before we serve one. It's not prohibitory, i.e. it can't require them to do something, to stop doing something. It requires them to stop doing something rather than to take action to do something. Before we issue one, as I say, we have to be satisfied it's expedient to use that. The notice takes effect again immediately and will only remain effective for 28 days. In some circumstances, compensation is payable if we issue one of those without proper consideration. Normally, you can only serve one temporary stop notice, and you can serve a temporary stop notice without an enforcement notice in place. Which brings me on to a stop notice. Stop notice you cannot serve unless it's either served concurrently with an enforcement notice or where an enforcement notice is in place. So again, it prohibits any or all of the activities which comprise the alleged breaches of planning control specified in the related notice ahead of the deadline for the compliance period of the enforcement notice. In this instance, the notice must specify the date it takes effect. That has to be not less than 3 days, so it can't be immediate. It has to be not less than 3 days, but no more than 28 days. Where an associated enforcement notice is quashed, varied or withdrawn, the stop notice is withdrawn and compensation may be payable. Again, a person who contravenes a stop notice may be guilty of an offence, and therefore that's when legal action can be taken. Planning enforcement order is a relatively new tool. What this is used for is, as I say, the immunity periods I mentioned earlier do not apply where there's been a deliberate concealment of development. So members may be familiar with a case, it was quite a well-known and prominent case where someone built a dwelling and concealed it behind hay bales. That was deliberate concealment. The person in that instance then claimed that it had been there for more than 4 years and was immune from action. What the planning enforcement order does, you can serve one of those and it effectively does away with the immunity period and you then can take action. Another little used but available tool to us is an injunction, where we can obviously go to the courts and get an injunction to stop a breach or an activity. Section 215 notices, it is called Section 215 because it's dealt with under Section 215 of the Planning Acts. However, we do a bit of a joint exercise with our colleagues in neighbourhoods, and they do from time to time serve these notices as well as ourselves. But effectively, a Section 215 notice is used where the land may be untidy, it might be a building that is dilapidated and detracting from the character of the area. And you can serve a notice requiring steps to be taken to remedy that breach. We have served one quite recently, quite recently on the former officers' mess at Flintham, where the building is in a poor state of repair. It's partially fallen down, and we are in the process, obviously, of trying to get that resolved through a 215 notice. Apologies, I've just clicked the wrong button. Again, the notice has to specify the steps that are required to remedy the breach and a time for compliance which must be not less than 28 days. Once again, person failing to comply with this is guilty of an offence. The route or the right of appeal on this one is through the Magistrates' Court, not the Planning Inspectorate. So if we serve a 215 notice and someone wants to appeal it, they appeal to the Magistrates' Court. In a previous role, I served one of these. We ended up in the Magistrates' Court. It was to do with a building that was in a poor state of repair. We argued that the building detracted from the amenity of the area. When the magistrate looked at it and the evidence that was before him, he said he didn't think it did because all the other buildings around it were also similarly in a poor state of repair. And we lost the case on that instance, but never mind. Moving on, just in terms of workload, these are some figures for the financial year 2019-2020. During that period, we received 235 complaints or inquiries. Set out in the report, you do have the figures for other years as well. And you'll notice, in fact, that in recent years, there's been a slight decline in the number of complaints that we've received. Set out there, I won't go through them all in detail, but you can see there's sort of the most common types of complaints or breaches that we are asked to investigate. One of the highest ones is building operations at 97 cases. If we then look at cases closed and the reasons they were closed, in 2019-20, we actually closed 280 cases. So we closed more than we received. That's because obviously there's some hanging over from the previous year. And again, when you look at these figures, you can see that quite a large proportion of them related to complaints which were unfounded. So obviously we got out there, it was either not development, nothing was actually happening, or it might have been the case that whatever was going on had ceased. Permitted development accounts for another quite sizable chunk of those complaints. And you can see along the bottom then, next highest two columns, planning permission was approved. So that's either when we looked into it, planning permission had already been granted, or planning permission was granted in a subsequent planning application. And 33 cases considered no further action was taken because it wasn't expedient to do so. This presentation and these figures, I think, will be available to members after the meeting anyway, so you can obviously digest those in more detail. In terms of notices served, this is a comparison. It's a little bit busy and very colourful, but this is a comparison with some of our neighbours in the Nottinghamshire area. We are the green columns, and this goes back to 2014-15, and you can see that highest number of notices served was in 2015-16. The last 3 years has been quite steady. Interestingly enough, Newark and Sherwood have been ramping up their action by the looks of it for various reasons. I think they do have problems in Newark and Sherwood with illegal encampments, and that might be an explanation as to why their figures are quite high. In terms of Gedling, this one's a bit off trend. I understand that in that year they served 32 enforcement notices. 20 of them related to individual garages in a garage forecourt where they were being used for commercial premises. So again, that explains why that perhaps is a little bit out of kilter with the trend at Gedling. So just moving on to some case studies and some issues that have been raised by members prior to the meeting. Councillor Phillips raised this one. It was to do with lands south of Wilford Lane. So it's the building site which is to the rear of the Borough Council offices, the arena. That development was approved subject to a condition that required a construction management or construction method statement detailing issues of how they were going to deal with noise, vibration, dust, etc. Because of the contaminated nature of the land, they had to pile the foundations, and they started using a driven pile method, which obviously created a lot of noise and vibration to properties in the area. We went through very quickly and served on them a temporary stop notice. I think I went down there myself with the enforcement officer at about 4:30 on a Thursday afternoon, and they packed up on that day, and they didn't pile for the 28 days while that temporary stop notice was in place. The other issue that it created, obviously it's very close to the schools along Wilford Lane, and they were in the exam period when the noise was disturbing to the children doing their exams. So we facilitated discussions between the developers and the head teachers, and they actually agreed to not pile during exam periods. The remedy in that instance, clearly piling is an inherently noisy activity. You were never going to deal with it totally, but they did things like fitting a different hammer to the rig, only piling at certain times, moving the rig around the site so that it didn't have the same intensive effect on some residents as others, in one go. So again, that shows where a temporary stop notice can be an effective tool, and I like to think that that was a successful outcome from the action that we took. And this is one that Councillor Thomas raised. This relates to a development on Kirkley Road in East Leek. It relates to the provision of the drainage for the site. And I have to say, this is one where we did have to chase the developers and spend a lot of time in dealing with the issues that arose. Effectively, they didn't put in all of the drainage that they were required to do by the trigger points in the conditions. I won't go into too much detail on this one because it's a very technical issue. And in fact, we did call on our colleagues in the lead local flood authority to help us resolve this issue. But effectively, you've got two large attenuation basins. There's a watercourse that runs through the site. There's a link between the two attenuation basins, which is all part of the drainage strategy for the site. The other issue, and you might just be able to pick out, there's a dotted grey line running through there. That is a right of way or an access route for someone to get to the paddocks to the top of the site here. And a condition required that that had to be reinstated. And again, there was a lot of work took place to make sure that that was provided and that a tractor with an articulated trailer could actually go along that route and negotiate the bends. Effectively, they have now, we've had confirmation, or we had at the time, confirmation from the lead local flood authority that everything was in place in accordance with their requirements and the condition. One of the issues I know that Councillor Thomas was concerned about and has raised is the fact that the watercourse that runs through here actually overflows into this, this attenuation basin. That's actually part of the solution for the drainage on the site, that in times of heavy rainfall, the water coming down the watercourse will spill over into this attenuation basin rather than continuing on down into the main brook along Brookside Road, causing flooding to the road. So the whole purpose of that is not to remedy any existing situation that may occur, may exist, but it's to ensure that the development doesn't exacerbate the situation and make flooding worse in the area. Just a couple of other case studies just to go through for you. Sometimes it may look like we're not taking action, or it's taking absolutely ages for us to take action. Unfortunately, the way that the regs are currently written, there's a number of pitfalls that people can exploit to try and string out the resolution of an issue. So this one relates to a situation where we had an illegal encampment was established on a site in Screveton. I think they moved onto the site on the 5th of January. We actually received notification, that was a Friday. You'll be impressed by this because we were actually still in the office at 5:15 on a Friday evening. We took a call that someone had moved onto the site. And obviously we started our investigations immediately. We returned to work on the Monday. They actually submitted a planning application which came in on the same day through the planning portal. So we had no prior notice that they were going to move onto the site, but obviously we then picked up the application from the planning portal. We did serve we served a temporary stop notice on the 20th of February. That was to prevent additional caravans being brought onto the site. And you'll note that although the application wasn't determined until the 2nd of March, we actually served the enforcement notice on the 26th of February before we determined the application. The benefit of that is that if someone's going to appeal either an enforcement notice or a planning permission, they can appeal them alongside each other concurrently, rather than appeal the planning permission, it gets dismissed, we serve an enforcement notice, it then goes to appeal and it strings the process out. We got notification from PINS that the appeal was lodged on the 7th of March. We were notified that the appeal was valid on the 29th of March, but here's where a big delay occurred. Because there are only certain inspectors that deal with this type of breach, PINS did not allocate an inspector until the 8th of August. There was then a hearing on the 13th of November, and ultimately the appeal decision was made or came out on the 17th of December 2018. In that instance, the appeal was allowed, unfortunately. Another one which we've had some recent success with, and I won't necessarily go through this in detail because again, you can obviously digest this, but this just is again a situation where the process was a little bit strung out. Looking at the dates, yes, we could have compressed some of them admittedly and done things a little bit quicker in the process. But again, this is a situation where they appealed the notice and that obviously delayed the process or the resolution of the case. Just pick up on this point here because on the 10th of July, we received council's opinion. It's not always crystal clear that something is a breach or what the breach is. If we're going to specify what the breach is in a notice, we need to make sure that it's clear what the breach is in that notice. And if we were to get it wrong, we could lose it on a technical point. So on this occasion, this was caravans in the curtilage of a property used as a house in multiple occupation. The person who owned the property or their agent was arguing that they were incidental to the property. We argued and confirmed by council's opinion that no, it was a change of use from a house in multiple occupation to a house in multiple occupation and a caravan site. So we did serve a notice here. The enforcement notice was appealed again, and ultimately that decision came through to us on the 16th of July. Again, there was another delay because of COVID, I think. We were notified that the site had been cancelled by the 16th.
It's not just me, is it? I assume the signal's been lost.
Yeah, I think so.
Hello? Am I?
Andrew, if you can hear us, we've lost your sound signal, basically. I don't know. Is it? Are we able to let Andrew know if he doesn't realise, or can we text him? Oh,
Yeah, Chair,
hang
I
on.
can send him a message.
Hang on, Andrew, you're back
Yes.
again.
Am I back?
Yes,
You got me?
the signal just sort of froze and disappeared.
Probably my modem. Don't worry, it's probably my Wi-Fi. So have you got me now?
We have indeed.
Good. Okay. I'm not sure where we got to, but we received a notification from the owner on the 3rd of August that the caravans had been removed. Once the compliance period had expired, we went and visited the site to make sure that they had been removed and they hadn't just been moved to another part of the site. So that's basically, there was a total of, I think, 4 or 5 caravans on the site. People were living in these associated with the house in multiple occupation, and 18th of August, all gone. Again, a successful outcome in my view. The other point that's been raised by Councillor Jones is not solely related to enforcement, but it's related to resources in terms of dealing with planning applications and enforcement. We have seen an increase in workload over the years. This is plotting workload, number of applications in blue, number of pre-application inquiries in orange, plotting the trend since 2010, 2011 up to last financial year. And you can see that there has been an increase in number of cases that we've dealt with. These are planning applications and related submissions. Slight drop off in the last 2 years, possibly COVID related. We don't know yet. We're keeping an eye on that. But you can see how the workload has sort of grown. I think Councillor Jones was concerned whether or not there'd been a commensurate increase in numbers of staff. Just looking at my establishment since 2012, it's approximately 3 full-time equivalents increase. There's been a bit of a fluctuation in the year since 2012, but in 2012 we had 16.49 full-time equivalents. We've now got 18.99 full-time equivalents. So we have created some additional posts. We've got 2 technicians which leave the principal officers of some of the work they used to do. We've got a contributions officer who helps with the monitoring of Section 106 agreements. And we've got the other one is a planning and appeals assistant, which is effectively an additional post that we created several years ago. Last but one slide, this just shows you the current structure. That's me just there. I've got 3 principals under me, and there are 3 teams. One effectively deals with the east of the area, east of the borough, one with the west, each with 5 planning officers under them. And then Mr. Cox, who's with us this evening, is the Principal Planning Officer monitoring commencement. So he does manage the Conservation Officer, the 2 Enforcement Officers, Planning Contributions Officer, and the technicians. He also does oversee applications in the West Bridgeford area. So he signs off under delegated approval applications in that area. So that's basically it from me. If there's any questions that members may have, I'm happy to try and answer those for you.
Great. Okay. Well, thanks very much indeed, Mr. Pegram. It has prompted a few questions from me, but I won't pose those yet, because I did say at the beginning that I had invited Councillor Jones to make his submission. So, Councillor Jones, if you'd like to show yourself in the nicest possible way, and click on your video. And are you?
I can't start the video because the host has stopped it.
Right.
So I can.
Um,
All right. Okay. I've now been asked. Okay. Thank you.
Right. Good. Okay. Right. Thank you for joining us and for making your submission. Obviously, time is fast getting on. So, could I ask you to just sort of present or summarise your submission? And I'm afraid that if I could ask you just to limit it to 5 minutes so that we've got time for further questions and discussion. So over to you.
Okay, I'll try. Thank you. My angle comes at it quite differently from that very competent technical presentation of the enforcement process. Back in February, I raised a number of issues about the absence of certain environmental and footpath measures on the Sharp Hill site, i.e. west of Melton Road. And Nick had to reply, or did reply, to say, unfortunately, the enforcement department is operating at 50% capacity and has done so for some time. So we've not been able to review your information or give you a response. So that led me to think, why is this enforcement? And that's why I raised the motion. And as you'll see from the examples that I've given in the report, the prime ones are not specifically the technical enforcement that Andrew's been describing, but they are a number of issues to do with big sites. And I noticed in the figures about applications, there wasn't a distinction between the volume of big sites and the volume of properties and issues on those sites and straightforward applications. So I still wonder whether the complement of planning staff is adequate to deal with the growing pressure on them. The issues that I've raised, and I've got a recent one that's been outstanding over a week, as Nick will know, is there was a lot of failure for over 2 years. Sorry, this phase 1 of that development was supposed to put in place certain environmental protection measures, i.e. to fence competently around the wood and to plant in certain areas, to plant a hedgerow connecting the wood to the bridleway by the cemetery. And much of that, this is 2 years ago, and various questions have been raised. And recently, the temporary enforcement officer, who's now gone off the scene, did actually meet with one of the changing managers of Bovis. And it's been agreed that they should put the fence all the way around the wood, and they should put it up in a competent fashion. And what's still not occurred is that, plus the wildlife corridor across the field. There's issues about a footpath and cycleway along the west side of Melton Road, which has not occurred. And there's issues, as you'll see in the report, about flooding and issues that I've raised there, which are the consequence of uphill decisions in the Taylor Wimpey site. Recently, a whole area has been fenced off with the safety fencing, which has cut across a right of way. And as far as I know, I've not been able to get a full answer about what is happening. Now, technically that might not be enforcement, but it is preempting enforcement if there is a strong connection between the planning section via whatever means and large developers who are not coming following the conditions and the requirements. The footpath is in the supplementary planning document, but the excuse me, many of the other things are conditions in the planning approval, and it seems to me that there's a missing link, and that may be at planning officer level between the planning section and large developers, because obviously the failure to do that can result in environmental harm and a lot of dissatisfied members of the public. I won't go through all the other issues that are raised, but those are the primary ones that I just see on my doorstep.
Great, well, that's kind of you. Thanks for that. And you did actually conclude your comments by suggesting possibly being more proactive and to have an officer, a dedicated officer, to spend more time looking at sites as they develop. And I assume by that you meant the large-scale sites.
I do, and I don't think that's necessarily an enforcement officer, but obviously that's the way it's been presented to me, that all these issues are largely enforcement issues. But I think, I mean, I don't want to sort of compare things, but in days gone by, the developers, and I had a meeting with some of them, with Friends of Sharp Hill Wood, and they knew Matthew Marshall and they had a direct connection and they understood who was on top of it. And I think the pressures in the planning section are maybe too great, I don't know. But I just see it not working in the way I would have thought it would have with liaison between developer and planning section.
Okay, right. Well, we'll explore that a bit further in our discussion. So thanks for that, Councillor Jones. If you could sort of switch your video off again so that we revert back to the members of the scrutiny group. But thank you for attending and making your submission, which is very helpful. So over to you, ladies and gentlemen of the committee group. Perhaps I'll just pose one question to Mr. Pegram, first of all, is that we have this wonderful short 4-letter word, harm. And I suspect there's probably several thousand definitions of harm. How do you actually define harm? Is it in the eye of the beholder, or is there a technical definition?
I think it's very much a subjective issue, and it's a matter of scale and degree as well. So harm can be negligible or harm can be significant. So again, it's a difficult one. I mean, harm could be impact on someone's amenities, so overlooking or loss of privacy to somebody's garden. It could be a highway safety matter, which is harm. So harm can amount to lots of different things and of different scales. And it is, I think, very much a judgment issue on officers to determine what that harm is and what the scale of the harm is. Okay.
Right. Members of the scrutiny group, over to you. I'd like to invite whoever would like to make a contribution, please. Don't all rush all at once. Right, so I take it that nobody wants to make a contribution. Councillor Thomas.
Yes, I'd like to say a bit more about the issue that Councillor Jones raised about proactively checking that conditions are being, work is being carried out properly. I think it's with these large developments, and we've had quite a lot of these cases in East League, whether various things are supposed to be done at particular times, it's before they start on the site, or it's before the first house is occupied, or before, a certain number of houses are completed or whatever. And at that point, they're supposed to, I believe, notify the planning department that they've reached one of those trigger points. And then there are certain things that they're supposed to do. But I don't think that even the notification part of it is necessarily done, let alone any checking at that point that they've done the things that they're needing to do. It's particularly important at the end of a site, obviously, when they're completed, and it's particularly important when some of these facilities are being passed over to management companies, and the residents could ultimately be charged if the work hasn't been done, or the work hasn't been done correctly. So that's one of the issues really that's concerning. I think Mr. Pegram was suggesting that that 50 homes would be a limit for, I can't remember what now, proactive monitoring, so making sure that things are done. And I'm not quite sure that that's the right limit. I think it maybe needs to be a smaller number, or it certainly needs to happen when there are management charges involved, and the these facilities are being passed over to, basically the residents will have to pay for them. Yeah.
Okay, Mr. Pegram, you sort of waved your hand at one point. Did you have a response to that?
Thank you, Chairman. Yeah, just to raise that was certainly one of Councillor Thomas's queries that she raised prior to the meeting about whether 50 dwellings was an appropriate level, and how we arrived at that. I can't remember exactly how we arrived at it, but what I would say is that with the exception of 2 sites in the local plan part 2, all the developments are for 50 dwellings or more, and therefore we felt that that was an appropriate threshold for proactive monitoring. One of the things that we will do, I mean, effectively, if there's a Section 106 agreement, the developer is supposed to give us notice of their intention to start on site. That is then the trigger for us to look through the planning history, look at the conditions and what needs to be discharged or should have been discharged. And that would then form part of the proactive monitoring.
Okay, right, thank you. I'd just like to ask a little bit about, and I think this comes under the section that when you talk about operations, and I'm using Councillor Phillips' example of piling as an example of this, but I don't want to limit it to that. I'm just using it as an example of a general question where it's fairly obvious, or did we know, because I have to confess I can't remember the details of the application at the time. Were we aware that there were going to be substantial engineering operations that would take place, i.e. in this case piling, and is there something that we could have or should have done to maybe anticipate that there was going to be a problem and to try and make some preemptive measures and get those mitigation measures in place at the time of the application, rather than waiting until there are a stream of complaints coming in from residents? So I suppose the basic question is there a way in which we can preempt where it is likely that there are going to be substantial heavy engineering operations during the actual building of the development?
I think the answer to that is generally the foundation methods that are used in the development are not a planning matter generally. They're a matter for building control, obviously, to ensure that the appropriate foundations are used given ground conditions, etc. It's something where we have gained significant experience, I would say. Clearly, if we are now dealing with any sites where there is contamination, where they are raising ground levels, we do ask the question. Having said that, the sort of method of construction and disturbance during a construction period is typically not a material planning consideration. Where we've got a construction method statement or construction management plan in place, yes, we can address these issues and pick up on them, but arguably it is questionable whether or not that is a planning matter. I mean, we certainly couldn't, in my opinion, refuse planning permission because a developer was going to use piled foundations, and that may cause temporary disturbance to residents while that development is being carried out.
Well, it was more a question of not proposing refusal, but ensuring that there were conditions in place regarding the method of operations. Surely, I mean, we, for instance, in planning permissions, we perhaps give timings. So, you know, you can only work within the hours of operation of X and Y. So surely from a similar point of view, can't we also preempt any substantial major operations and say that they can only be carried out with the prior approval, or that details have to be submitted to the council prior to those operations being carried out?
I think again, it's questionable whether or not it is a matter which we should seek to control through planning. Dare I say, and it might ruffle feathers, but nuisance or disturbance caused by development is a temporary inconvenience, potentially. You're going to get some disturbance. Unfortunately, the houses don't just appear overnight. There is development, there is dust, there's noise, there's vehicle movements. I think on the bigger sites, we do try and pick it up. We've never been challenged on it, but we do try and pick it up through the construction method statement in terms of hours of operation, vehicle movements, dust, noise, vibration, etc. But it is questionable. I don't know if Mr. Cox has got any comment to add to it, but I think it is questionable whether it is actually something we should even seek to control.
Fine. Yes, by all means, let's bring Mr. Cox and bring the changes a bit. Do you have any comments?
Yes, only that it all depends on the site, really. I'm aware of some major developments who aren't necessarily sure at the time of application submission whether piling will be needed or not. It's only really when they get to investigate the land after post-permission, planning permission is granted, will that be considered. Same with power floating of floors, etc. So there are some elements that aren't necessarily known at the planning permission stage, which is why they often get wrapped up in a planning condition about the construction management plan. But it's the noise and disturbance arising from general development activity, I would say, falls firmly within sort of environmental health sectors. It's for us really to ensure that, like you say, the hours of the development are respectable and that they won't necessarily cause harm for the general activity taking place to the neighbours that are adjacent to the site. Now, I know that's been a bone of contention with members for various sites around the borough, but that is a fairly common requirement for construction management plans to be imposed as a condition. And we do scrutinise those with our environmental health colleagues to ensure that, the best working operations do take place as the development gets built out. I think one thing to appreciate is that there are sometimes anomalies, and developers will react, to ground conditions, or if there's a delivery, then sometimes it's inevitable that some of those parameters will be breached in some respects. That doesn't necessarily mean that warrants an enforcement notice or a breach of condition notice. It has to be something that's persistently in breach for us to consider that to be expedient to take action against, not just the odd miss of an agreed time, I would say.
Yeah, okay, thanks for that. I suppose the only response I might make to that is that from the public perception point of view, it is the council that is handling the planning application, and perhaps it's unfair to use the phrase, but there's a bit of a perception maybe of trying to pass the buck to a different section that's responsible for it. But at the end of the day, as far as the public being inconvenienced, it's the council that they go to, rather than any one particular section. Councillor Brennan.
Thank you, Chairman. Yeah, I have a couple of, I guess, observations and a question. We're being asked to look at the policy and look for areas for further investigation. I have to confess, it's one of the surprises, well, there've been many actually, but one of the many surprises of becoming a new elected councillor was the fact that this is not a mandatory service. And the fact that it's an option to have an enforcement process or not strikes me as quite odd, and is something I still struggle with, because if you're going to have any kind of a regulatory regime of any kind, if you've got no means of enforcing it, then there's very little point in having it in the first place. So I suppose my question is, and given the context where we're looking potentially at reforms to planning, which is going to emphasise more and more building with fewer and fewer restrictions on that, what is the purpose of the planning and enforcement function? And to me, the question would be, actually, it strikes me that we're going to need more, not less enforcement. If you've got a more flexible, less intrusive policy, then the few things that you have got to restrict development and to ensure that it satisfies whatever requirements have been imposed upon it, the more important it is that we've got resources to enable us to ensure that those requirements are being held to and fulfilled. So I suppose one of my questions in this is, do we have sufficient resource if we're going to take either a more proactive approach under the current regime, which is to say that we should work more closely alongside developers to identify breaches before they arise. And I applaud the idea that we're not measured by the number of enforcement notices. In fact, one of our great achievements might be to keep those to a minimum, but nonetheless ensure that whatever conditions are being imposed are actually applied is a better result than issuing enforcement notices. But that's not in itself something that is lacking in staff resource, I would have thought. I mean, you need as much resource to work alongside a developer to ensure it's fulfilling its statutory obligation or planning conditions as you do to enforce them after the event. So I suppose what all this is leading to me is, I don't feel convinced that we do have sufficient resource. I don't think that enforcement should be an optional extra. I think it should be something that's embedded. And I know this is a national issue, not a council issue. But for me, I would wish to see this role strengthened both under the current regime in terms of closer working on some of the issues that have been raised by Councillor Jones and others, but also to preempt what might happen in terms of a change of planning regime that enables developers to have more freedoms, and possibly without anybody checking whether they've abused those or not.
Yeah, I'll bring Mr. Mitchell in just a second, but yes, you're quite right on two fronts. The resources issue, that will be an issue to discuss at a budget workshop, no doubt, to decide on where to allocate resources. But you're quite right that with the potential new planning regime coming in, or the white paper consultation, we're not quite sure where that's going to take us, but certainly I agree with you. We ought to be taking the opportunity, if at all possible, to strengthen our hand, because it is possible that the new legislation, if you take it from a very crude point of view, oh yes, you can build anything you want, so long as it is, I quote, in keeping, then who is going to judge and decide what is in keeping? And I'm sure that will exercise many planning lawyers for many decades to come, as Mr. Pegram nods away. Anyway, Mr. Mitchell, would you like to respond to Councillor Brennan, please?
Yes, thank you very much, and thank you for bringing back to the report tonight, which introduces the policy. And the policy is there to strengthen planning enforcement under the current legislation. And as the chairman says, we're currently looking at the planning for the future document, which identifies that the government sees that there should be an increased enforcement. So indeed, we may have to change this enforcement policy in the future. But it's better than we've currently got. And your comments tonight are very much appreciated on that, so we can then bring it back and then hopefully then get the policy adopted until that later guide comes in. Now it comes down to the implementation, and as a lot of people said, it is not mandatory, it is discretionary, and indeed we don't get paid for that. So we are providing a service to, and it can be a very lengthy process to take enforcement action, which doesn't get paid. Now I'm currently working with Andrew and the team to look at the resources associated with planning. We have a consultant looking at the overall resources to say, have we got it right? Are we? It's easy to say, and enforcement is very emotive. One person will want it, strict action taken, and Andrew and his team, and it's not just the enforcement officers, it's the planning officers, have to look at it and go, is it right? So on one side, someone will want action straight away. On the other side, we have to work with legislation to take appropriate action. And that can be frustrating. Councillor Jones kindly mentioned, he rightly mentioned, that the number application doesn't really illustrate the amount of work going on in planning. Because you can get a lot of applications that are very small and very quick and easy to deal with, and indeed in enforcement terms you probably never hear of them because they're dealt with a neighbour or the applicant and never come forward into the public domain. It's the big sites the problem. So as Andrew said, we have 27 local plan part 2 sites and 6 local plan part 1 sites, all of them 50 and above houses. To look at Councillor Thomas they're all going to have section 106s, they're all going to have open space requirements. Now open space requirements we're dealing with in a separate report that will be coming back to this meeting next, at the next meeting. But in terms of enforcement, you look at those big sites and look at the income that the planning service is getting, and that is significantly more over the last few years, because we're taking on those local plan part 2 and larger sites. So I anticipate the consultant will come back and say whether we might need some additional resource. It wouldn't necessarily have to be in the enforcement function, it could be in planning or a specific officer. Indeed, as Councillor Jones mentioned in his papers about the large sites officer we have. We now have a SIL officer who looks at conditions. So those 2 officers can start to work together to look at condition applications. I think the key bit really is that we need your comments on the policy. Is it strong enough? And then we need comments on the implementation. Are we implementing it correctly? And that comes down to resources. But I can, on one hand, I can mention the 5 or 6 key enforcement activities that are very frustrating across the borough, that are very high profile, but you don't see most of the work of the team. Thank you for that, Chairman.
Okay, thank you very much indeed. Yes, I mean, this potential of resources and of income is going to be quite serious if the ideas of the white paper genuinely do come to fruition, because potentially we will lose planning application in its simplest form, lose planning application income, and yet the public will still expect us to enforce it with no resources and no income. So it is very difficult. I've got Councillor Stockwood, and then Councillor Brennan wants to come back. Councillor Stockwood.
Thank you very much, Mr. Chairman. I apologise in advance. I'm hearing people's voices go in and out, so perhaps it's me that's on multiple people speaking, so perhaps it's me that's got a wireless problem. In considering, you've got policy before you, and it's got a very detailed policy. In my understanding of this, how we consult with and work with the public with regards to planning function, we start with the statement of community involvement, which is another one of our policies. That talks about how we will engage members of the public before planning permission is granted. So I'm imagining that a planning enforcement policy is about what happened as building goes on and after construction or some form of development has occurred, I think. So in regards to feedback on the policy as presented, I think there should it would be helpful if the statement of community involvement and the planning enforcement policy are presented in a similar way, with similar terms as such. With regards to the 50 house limit, I'm always recall that the statement of community involvement defines major and minor applications based on 10 properties and the scale of retail development. So perhaps when choosing a division between proactive for large developments, we could use the same definition of minor and major, so that it's clear across policies. I mean, it's just my understanding of things. With regards to the presentation of policy, I think this, I welcome an advanced access to an early draft, but I do think dividing the policy into clear processes for if you want to make a complaint and what happens if you are complained about, and make it quite clear through formatting the step-by-steps that would happen in each scenario. With regards to looking particularly at page 23, I do agree that the matters that are not breaches of planning control covers many of the issues that residents are concerned about. However, some of those points are actually other policies are relevant. So it could be the case that and in particular, advertisements. I don't understand advertisement law, and down on priorities that we would actually investigate. Illegal display of advertisement is one of the ones we would look at. So I just perhaps in presenting the policy, I think it might be the case that people would be best directed to other departments or other organisations, or a suggestion is that if they have got some other one of these concerns, that they could contact customer services to be directed to the right place for their issue. I mean, a lot of them, I fully agree with the statement about private neighbour disputes, but high hedge disputes and other things are actually things that would be investigated under another policy, and the person who is reading this, trying to figure out how they do something about the issue that they're facing, may benefit from being directed to the right policy rather than simply being told this is the wrong one. So that would be a positive sort of way of explaining that you've got the wrong policy, but you want to look at something else. So that's my general points are with regards to there's an existing policy called the Statement of Community Involvement, which covers how we consult during planning applications. I would like to, some sort of the formatting that I see in that document is very open and very clear in the paragraphing and the processes that are being gone through. And I would think that, the policy going forward for planning enforcement could benefit from similar terms as that policy. And I would also highlight that in policy, it may be beneficial to mention that additional support would be offered to people with seldom heard groups, which I'm sure everybody was going to do anyway. But sometimes it's helpful to mention to people who are particularly struggling with complex documents that time will be given to help them to understand how to work effectively regarding their concerns when they have to deal with council services. So I'd just like to make those few points. I welcome the draft and hope that we see it again in the next meeting. Thank you very much.
Okay, thank you. Councillor Brennan, who wants to come back?
Thank you. Yeah, it was just to respond back to the points that, that Mr. Mitchell made. I do welcome the policy. I think it's very clear. I think Councillor Stockwood makes a very good point that some of these issues are dealt with elsewhere, and it's good to not just reading it, you might just assume it can't be dealt with anywhere. So I think that's a very good point. I still come back to the point of ability to deliver it, though. It's no good having a great policy if we simply don't have the resources to enact it. So I'd still like some, I suppose, support to this policy that makes clear that there are sufficient resources in the council currently to enable us to deliver it, and some to be satisfied that that is the case. before this is formally rolled out.
Okay, and just building on that, no pun intended, also from a resources point of view, perhaps we could be asking the officers to almost preempt or foresee, not necessarily how the white paper is going to end up, but there is no doubt that there are going to be changes, and there is no doubt that we will end up seeing more development taking place without going through the detailed permission process that happens at the moment. And so is there a way of trying to forecast or have a potential plan in place to increase the resources to allow that proactive element to work with the developers? And you know, Councillor Jones did suggest this, but what I have in mind is it's a bit like with both the police force and with the health service. You know, that the police are there if you can prevent crime, that costs less than having to solve the crime afterwards. If you can prevent an illness, that is cheaper than having to try and cure that illness afterwards. And so maybe I'm being very naive here, but by trying to be a bit more proactive, would we actually reduce the amount of resources we then have to put into enforcing something if something goes wrong? And with the extra development that's no doubt going to be forced upon us in some shape or form from the next local plan round, which is just commencing, maybe we try and get something in place rather than having to close the gate after the horse is bolted. I just sort of float those ideas. I think, Mr. Mitchell, did you have your hand up? I can't.
Yes.
I've got you, Councillor Thomas. Yeah.
Just to pick up on Councillor Stockwood and Councillor Brennan, the statement of community involvement will be going to Cabinet as a minor revision in September to take account of COVID and consultation during the COVID pandemic. And some very good points on the policy. Thank you very much. In relation to the resources, I would just repeat, we are doing a resource review at the moment with an external consultant, and that hopefully will be ready to feed back to you in October. I would emphasise that the council sets the policy and officers then deliver it, and if you don't think we're delivering it correctly, then you take us to task. But if I can bring back that resource review to you so you can be confident that we either need more or we've got sufficient, but it won't necessarily just be enforcement officers, it will be looking at the whole planning service. As Andrew identified, it's the whole structure. Every planning officer has a role in enforcement. So, thank you.
Could you just clarify, well, one of the officers anyway, are there definitely 2 enforcement officers actually in post at the moment?
There are. It was a sickness issue, and we did bring in a temporary, as Councillor Jones mentioned. Any small authority, we are dependent on a small number of individuals. So, Andrew, planning officers are difficult to get hold of, but we did get a planning enforcement officer, a very experienced officer, to come and replace that. Our office is now back and delivering. And just one point I forgot to mention in relation to the planning for the future, Chairman, that you mentioned. We are doing member briefing sessions in early September, followed by a local development framework to consider our response to that. So hopefully every council will have an opportunity to put in a comment. Thank you.
Right. Yeah, your sound definitely keeps coming and going. I don't know what, it's obviously something, I don't know if it's your microphone or whatever, but it does keep coming and going quite often. Right, sorry, Councillor Thomas.
Yes, there were 3 things really that I wanted to pick up on. I'm quite liking the emphasis that everybody else is putting on proactivity, and that needs to, I would suggest, be built more into the policy, so that it is feeling like a proactive response. On resourcing, I did pick up when we were given the budget outturn that there was a huge positive variance on income on planning application fees. And it did occur to me that perhaps that ought to in some way be related to the appointment of staff in the planning function, and whether that could be looked at. You know, I would think that would be a possibly quite a productive line of inquiry. And the third thing was on the policy, and I have mentioned this in the document I put together. I think that some more work needs to be done, perhaps on the prioritisation criteria. On this, I think it's page 25, because it kind of covers two different things. There's a sort of triage function, isn't there? So when do you actually need to identify those cases, when you need to go out and stop something happening? And that is one sort of prioritization action. But going forward, you know, when you're looking at the cases and keeping them going and making sure something's happening, there's a different level of priority, which is based on impact and harm. So I think possibly a two-stage prioritization regime, as it were, would be helpful. Thank you.
Okay, thank you. Mr. Pegram?
Yeah, Chairman, just on the prioritisation issue, this is a matter that Mr. Cox and I have discussed, and we do want to revisit the prioritisation, and we can certainly pick up on Councillor Thomas's comments. But at the moment, clearly what we do is something which is going to cause irreparable damage. So if someone's knocking down a listed building, we'll be out there like a shot. If it's someone who's built a fence, clearly there's no rush in our view to get out to look at that fence. So we do, as I say, but the point I wanted to make is that, you know, when it comes back to you in October, I think it is, we do want to have a look at the prioritisation and revisit that issue, and we can certainly build in Councillor Thomas's comments into that.
Yeah, which just prompts me to comment, because we haven't really talked a lot about some of the councillors' submissions that were made. But what legally, is it up to us, when I say us, the council, is it up to the council to decide the prioritisation, or are those priorities set in any planning legislation? For instance, well, obviously just taking the first one, and the other priorities, breaches of conditions, and as you've indicated, some might be quite serious and others might be pretty minor. But is there a case for looking at how we prioritise the priorities? And do we have the scope legally to do that, or are we have we got both hands tied behind our backs?
I think the priority, there's nothing in national legislation as far as I'm aware. It's very much down to us to determine our priorities. But clearly we need to ensure that we don't set expectations that we can't achieve. So as I say, yeah, it's for this this council to determine its priorities. The process for the adoption of this document, it's come to you at this meeting as part one. It will come back in October. It will need to go to Cabinet for consideration and out for a public consultation before it then goes to full council for adoption. So there are a number of stages that this has yet got to go through before it can be adopted.
Okay, well, I'm conscious that time is very much getting on. So the submissions that have been made by other councillors, so have they been circulated as yet?
No, they've not been circulated as yet. We tried to pick up on some of them through some of them are preempted in the report. We tried to pick up on some of them through the presentation. The intention is that we will circulate a document after this meeting. We'll finalise it, pick up on some of the additional points that have been raised, and circulate it as sort of a Q&A document, so that you can then obviously consider that before the next meeting.
Yeah, so if we can have that circulated so we can consider that. If members would like to really cogitate over the priorities and indeed any other parts of the policies which they feel needs addressing, and so that we can incorporate all those in our next discussion and try and come to a conclusion as to what recommendations we make, if any, to the draft policy. I'm sure there will be some changes recommended in view of the comments tonight. So Councillor Stockwell's just put his hand up just in time, because I was just going to go to Mr. Mitchell to just very quickly give a bullet point summary of what you think is necessary to do before the next meeting. So I'll just give you a bit of time to think about that while we go to Councillor Stockwood.
Thank you, Mr. Chair. Just a brief point of information. There is a chat comment from Councillor Jones, and perhaps Democratic Services can record that and add it to the Q&A document that's going to be presented. I just wanted to make sure that that chat comment wasn't lost.
Yeah, if anybody hasn't read it, it refers to if vegetation is stripped from the fields, then obviously you've got surface runoff going into properties further down the site, which, yes, I'm sure that many, in fact, we have that actually in Ratcliffe-on-Trent. Councillor Brennan's was quite involved in trying to deal with residents' complaints from a brand new development where that very thing started to happen. So it's quite a common occurrence. So yes, we should include that, certainly. Mr. Mitchell, can you just draw this to a close so we can move on? Are there any particular points or what points have you actually gleaned from this that you
Hopefully you can hear me. I've gone onto a different microphone. Is that better? I don't know whether.
Is at the moment?
Yeah.
Yes.
Yeah. I think there's 3 points I picked up. One, thank you very much for those comments on the policy. And Andrew and Nick will take those away and look at revising that policy and taking into account. And there's some very good points about links to other policies and not leaving them to go down a blind alley. The second point is on the comments on the resources. And we'll again take those away and bring them back to you in the October meeting with the resources. And the third point, and thank you to those who submitted their comments before the meeting. We would look to bring together a sort of question and answer session of all those points that you raised. Andrew's already started this, but from tonight there may be a few more to give you an overview of any questions that aren't in the policy to help you understand it. So that's the 3 actions I have from the meeting. Thank you.
Right. Okay, right. Thanks very much indeed for that. And thank you, Mr. Pegram and Mr. Cox, for joining us and helping us through that item. And thank you for all the work that you do. And please do continue working hard on our behalf. So thank you very much indeed.
Thanks, Chair.
Thank you, Chairman.
And have a good evening. Or what's
left of it? Yeah.
What's left of it? Okay, right. Moving swiftly on to item 5, and I'm sorry to have kept Shirley Waltman and Greg Dwyer waiting, but if perhaps they can be clicking on their videos to come and join the meeting for the item on customer services and digital transformation. And I can see Greg Dwyer has joined us. Hello there. And Shirley Waltman has joined us as well.
Good evening.
Good evening. And I think the Customer Contact Centre has enjoyed a little bit of a roundabout at the moment, hasn't it?
Politely put, Councillor Clark.
Moving around Westbridge for various reasons, property and also COVID. Oh, you've started screen sharing. I wonder why.
Well, I'm just preparing.
Okay.
Hopefully you can all see that.
So welcome to both of you. And by the look of it, it looks like Shirley, you are starting off your presentation. Are you?
I am. Yeah.
Please do fire away.
Okay. So good evening, everybody.
Sorry, could I just, for the benefit of some newer members who may not be familiar, if you could just describe your role, please.
Yeah, absolutely. So I'm Customer Services Manager for Rushcliffe, a bit husky today, bear with me. And I've been with the organisation for a number of years, and part of my presentation is going to take you through some history of the customer services and how we've got to where we are today. So I manage the customer services team, both in a central function in the centre of West Bridgford and also at our remote sites around the borough, which again I'm going to talk about in some detail as we go through our presentation. And then Greg is going to join at the end of the presentation and talk more about the digital side of things and how we're developing. So to start with, back in 2005, Rushcliffe had a one-stop shop based at the Civic Centre, and that was quite forward-thinking at the time. Rushcliffe was one of the first in the country to have a one-stop shop, and there all the customer service advisors were trained and able to deliver a number of back-office services. So the ambition being that everything got resolved at the first point of contact wherever possible, and our back-office colleagues were able to do the back-office work. We progressed in 2007 to see what we could do in more locations, more rural locations around the borough. And we opened up 6 contact points within partners buildings, police stations, parish council offices. Very much a surgery basis, 4 hours a week. And it was just a face-to-face service at this point. And some were busy, some were not so busy. We got to 2009 and we began a partnership with Metropolitan Housing Trust. They used to be based in the Civic Centre, and they'd made a decision to move to their head offices over on Alfreton Road. And so they needed somebody to deliver their face-to-face offering within Rushcliffe. And we continue to do that. The partnership's changed over the years, and we certainly do less now than we used to back in 2009. And we're continually looking at different ways that we can support the MHT customers. 2011, and Councillor Clark, you'll remember this, was a very busy year. We moved to West Bridgford Police Station in a really big partnership move where we started working with Nottinghamshire Police. And for those of you that aren't aware, we brought together 2 teams of staff. So we had inquiry clerks employed by the police, and we had customer service advisors employed by Rushcliffe Borough Council. And I managed the one team. We brought them together, and they learned the services of each organisation. So there was a seamless service delivery. Anybody that came in and wanted to speak to somebody on a council issue didn't know and absolutely didn't need to know who was actually paying their salary, whether it was a police employee or a council employee. And it worked very well. And we were there from 2011 until this year, when the police had obviously made us aware that they were going to sell the police station, and we needed to look for alternative premises. We also reviewed demand at contact points in 2011. And as I mentioned, some of them were busy, some of them were not quite so busy. And what we wanted to do was focus on there where we knew there was a bigger demand. So 2013, along came Bingham Medical Centre, and we were able to give a full-time presence in Bingham Medical Centre. And then 2018, obviously we're now in the Cotgrave multi-agency site, and we've got some advisors in there. And then we moved to Eastleek for about 10 minutes before COVID struck, and we started delivering some form of service in Eastleek. Obviously, at the moment, we're not in any of the contact points. We're working with library services to try and get something going again in September time, but libraries are open on very restricted hours at the moment. So we're working closely with them, but that might be something we start to see in the next month or 2. For those of you who haven't been in Fountain Court, it's small. There's no other word to describe it, really. We did lots of work when we moved from the police station into Fountain Court to look at footfall and how customers were accessing services. And there'd already been some move to people trying to do more online, and we were seeing less footfall through the door. Whilst ever there is any social distancing restrictions in place, Fountain Court will prove very challenging to open on a drop-in basis. However, what we have done since June the 1st, we've been open to customers who want to come and see us or need to come and see us and can't find an alternative way of accessing council services on an appointment basis. So our customers can ring the contact centre, they can be made an appointment, and they can come and see one of the advisors in Fountain Court. The surprising thing is how low that demand is and how it continues to be. I checked the figures today, and we're still averaging 5 customers a week that actually want to come and see us on a face-to-face basis. We're not alone in that. Other Nottinghamshire authorities are all seeing the same, in fact, nationally seeing the same. Some of the other local ones haven't opened any face-to-face yet. They're hoping to do so in September. But everybody that I come into contact with is very much doing an appointment-only basis. So similar trends, similar low level of demand. As I say, we also opened in Eastleigh, but blink and you missed it. We have a number of partners that we've worked with. I've already talked about the police. We continue to support the police in terms of in Fountain Court. We have a phone that goes directly through to the police control room. So any customer that needed to come in to make a call to 101 would be able to do that. And of course, we have self-serve terminals. And if they needed to get onto the police website, we'd absolutely support somebody to do that electronically. And Metropolitan Housing, we still continue to work with. Libraries we work with much more because both at Cotgrave and Eastleigh we're actually in library premises. So we've worked a lot with those and Bingham Health Centre to keep our contact points going. Citizens Advice Bureau, again, prior to COVID, did 2 drop-in sessions a week. At the moment, they are not looking to start that again. And we would struggle to enable them to do that, to be totally honest. But we're hopeful that at some point in the future, that facility will come back. But the CAB at the moment are dealing with everything over the phone. It's always been, when I go back to 2005, it's always been our ambition to try and resolve all inquiries at that first point of contact. What we've seen over time is trying to move more and more of the back office work to that front point. And this slide just talks a little bit about a couple of example areas of where we've done that. And if you look at home alarms, for example, back in 2017, we were more or less a switchboard facility. Somebody would come through, they would tell us that they want to speak to somebody about home alarms, and we'd actually connect that through to the back office. Now what we actually do, yes, it does take nearly 13 minutes on average to be able to complete that, but that customer's spoken to one person, and by the time they leave us, they've had an appointment made for them. They know exactly when somebody's coming out to see them, and we've spoken to them about everything that they need to know with the service and not had to speak to anybody else. So it's just that acceptance really that sometimes durations will go up, but actually customers are getting a more improved service because of what we're doing at that first point of contact. As I've mentioned previously, contact points, I thought you might be interested in how many customers we've actually seen there. So we opened in Bingham, as I said, at full-time, Monday to Friday in 2013, and we've just seen 12,500 customers there since that time. Cotgrave, coming up to 3,500, and Eastleigh, I've said. Customers can mainly do the same business at contact points that they can at the centre in West Bridgeford. The only real difference, we don't take any cash for obvious safety reasons. The other bonus is that our advisors can take telephone calls from the call centre while they're sat there. So, for example, at Cotgrave, we tend to have 2 advisors at Cotgrave because we're often in there when library staff aren't there. So we need to just make sure that we've not got lone worker and that we've always got some support. But what that does mean is that often they won't have a customer stood in front of them, but they will be taking calls from the contact centre, so that face-to-face customers can be seen, but the phone customers are still being treated as a priority as well. We have seen some channel shift over the years. I think the biggest interest, if you see how many on that slide, how many people now contact us by email and are happy to do their business through customer services over the web. I think this one's quite interesting. That's just because I work where I do, but 1920 increase in demand down to a snap election and 2 bouts of flooding. And so just for interest in election can generate in excess of 4,000 additional inquiries just related to the election. So lots of things that we deal with, we can predict. I always know when annual billing is going to be, and I know when we're going to charge for green waste. Unfortunately, Boris hadn't had a word with me about the snap election. So that's when we start to feel the unpredicted demand. Through lockdown, these next figures are just comparisons really of the same time period in other years, just to try and demonstrate how people are contacting us. And again, as you can see, lots of people contacting us by email. Our telephone calls have remained what we'd expect really, bearing in mind that lots of people have been locked down and actually not doing a lot anyway, but we've remained busy throughout that period. And we've done lots digitally. So we had the Digital by Default programme from 2014 to 2017. And as you can see, we've seen the increase that you'd expect of people happy to do website inquiries with customer services. Emails is big demand. We do have self-serve kiosks that are available for people that want to come into the contact centre and do their business themselves. That demand's gone down, I have to say. Generally, if you're happy to do stuff online, you tend to be happy to do it from home. Those people that do come in perhaps need some support to complete forms, or just a bit nervous about technology, or whatever that might be. So we're always ready and happy to support people if they do need to come in and see us. We continue to look at our online forms to see what more we can do to make online services accessible to customers. And another change that we made recently, when probably about 2 years ago now, if a customer brought in some documents that needed for, let's say, for a benefit claim, and they needed to bring in some evidence, we would take a copy of that evidence. It would go in the internal mail, it would go up to the arena, and it would get scanned onto the customer's account. We now do that at that first point of contact. It's another thing that we've just found of doing it at that first point. So the customer comes in, and within seconds of them being with us, that information is actually on their account. So in terms of a benefit application, that means that the benefits assessors can start assessing that and the information much quicker than it used to be. That was very whistle stop. Shirley Waltman, for those of you that know her, normally waffle on for hours. That was very swift. I'm going to pass over to Greg to talk you through, but I'm still doing the technical bit, so you'll still see and hear me, I think. Greg, over to you.
Hi, thank you, Shirley. So I'm the ICT manager for those who haven't met or spoke with me before. And so Shirley's gone through a background of customer service perspective and just touched on the digital side toward the end. And there was a Digital by Default program previously, and a lot of work, as Shirley mentioned, had been done to get us into the digital world and the digital presence. It got revitalized in 2018. The program is now Digital by Design. We have a new digital strategy in place and a new way of targeting the market as it changes, as technology changes. We need to move with the times. For instance, smart devices and such, and how easily more accessible they are to our residents. So we replaced the Digital by Design program, Digital by Default program with Digital by Design 2018, and a board of members were gathered and mandated to set out the strategic themes delivered to do with digital. So these are the themes in which the Digital by Design is covering. So it's digital culture. There's still a lot of work we can do to be more digitized. I think the lockdown, in a positive sense, has done a lot of, given us a lot of benefits to the organization and shown how we can deliver a lot of services remotely and using technology to help us achieve that. And the culture, digital culture of the organization has changed drastically through those events that have taken place. And I think we're keen as an organization to carry forward those benefits that we've seen from that. Efficiencies and reducing overall costs is always something that we're going to be seeking for. Customer satisfaction, you know, the last thing we want to do is deliver digital services that are either not needed or not relevant. And so we always have our residents to mind in terms of bringing these new services out to our residents. And security and privacy by design. So obviously, whenever we bring out new digital services, we've always got to make sure that we are keeping residents' details, their data secure and safe, and their privacy as well, especially around what happened in 2018 when the whole Data Protection Act changed, and making sure that we are adhering to those new guidelines, those new regulations to dealing with privacy. So some of the, just to give you a flavor of some of the things that we have delivered since this program was put in place in 2018. One of the biggest changes we've made, but it was more of a back-end change, was the customer relationship management system. Historically, it was an in-house system. It served us well for many years, but obviously by moving with the times and becoming more integrated and being able to get access to a lot more functions and features to allow our digital footprint to grow and our integration with all of our back office systems, we need to make a change. And we made that change, and it's brought us some benefits, one of which is the My Account portal. So we now have the ability of our residents to log in to their own account and access information relevant to them. So it could be things like when their bin collection is, who their parish or where the parish is and their councillor, updates on any inquiries. So that's something that's really relevant. So if they've got an ongoing issue or an ongoing inquiry with the contact centre or the council, it will give them updates as to where that's progressed to because of that back-end integration. So it gives them that instant response. That is actually going to grow over time. So we've introduced some functionality there for self-service, but that will grow. And the idea is something that Shirley touched on previously about the one-stop shop, that we was ahead of the game with that. This is what we want to try and do in the digital world, where you have the My Account portal, the one-stop shop that people can go to gain access to information and queries and basic queries, again, freeing up the CSC staff. The accessibility standards 2.1, that's more of a standard that we'd follow to ensure that our digital services are accessible to everyone. So we're not discriminating in any way, and that our websites and content is easily accessed by all. And we have looked at expanding our mobile technology drastically as well over those last couple of years, using mobile technologies out in the field. So things like tablets, where our officers, enforcement officers or other officers can go out into the field, have tablet technology that gives them live, real feed into the back office systems and update it instantly. That gives us efficiencies in terms of getting back to our customers straight away, and also prevents us from double entering the data when they get back into the office. So there's quite a few efficiencies been saved, and there's still some more work to do there across our organisation to continue that work forward. So these are some of the projects that we've got this financial year that we're looking to bring forward. Some of these are happening quite soon, so they're about to go live. So garden waste, for instance, that has been completely refurbed in terms of how we deliver that on the back end. It was a very manual process, lots of opportunities for error, human error. And so obviously by going down the automation route, you remove any of those errors from occurring. It is almost 100% automatic now, and a lot of, again, back-end integration. So that garden waste subscription for residents to be able to go in and subscribe, they've already got that ability to do that, but we're looking to extend that further in their abilities to set up direct debits and such, or automatic payments. But in terms of efficiencies that the new process has given us in the new system, and linking in with the My Account portal, gives a much more rounded service for the residents, and also better efficiencies for internal staff and the back-end integrations. Implementation of scan stations. So this actually enhances on what Shirley touched on earlier about us doing the scanning for our residents. So this again is something that's going to be launched soon, where a member, a resident can walk into the CSC and they can scan all their documents in straight away, self-service again, so it puts the resident can do this themselves. They don't need to queue up and wait for a CSC member of staff to do this for them. They can scan those documents and it walks them through very easily what type of documents they are that they're bringing in as evidence for whatever requirement they've got, and then automatically puts that into our back office system. So there's no staff processing any of that between them scanning it and it being in our back end system. So it cuts out the middleman in that sense, freeing up CSE staff to be working on more higher value tasks. The phase 2 of Meritech and My Account portal. Now Meritech is just something I've thrown in there as another term. That's basically the platform that we're using for the new customer relations database and the My Account portal. So the phase 2 is how we're going to enhance it further. So we've introduced it, we've got the My Account portal, and we've got some back office integration. We're going to look to expand that even further to bring more efficiencies and drive and bring some more benefits to the organisation and residents. We've got some new energy management software that we're looking to introduce to help manage our energy, whether it's electric, gas, water, and so forth. So we can look at monitoring our energy usage and looking where we can make improvements. Introducing a new online booking system so our residents can actually make payments directly as opposed to going through a manual process. to making online bookings. So that's to enhance that for our residents and speed up that process and have live access to appointments as to what is and isn't available, as opposed to waiting for feedback on that. Delivering hybrid virtual meetings. This has been a massive project that is basically come to light since the COVID-19 situation. So again, this is a prime example how our culture has changed due to COVID pandemic, and how the council were reacting to the new ways of working and what they call the new normal. And being able to deliver hybrid virtual meetings will allow us to have meetings like this, where some members of staff or councillors are in the actual office on premise, and then others are working remote. It's something that hasn't existed before now in terms of council formal meetings, and it's something that we are introducing in the not so distant future. And gov.delivery, I'm not sure if anyone has heard of that term, but it's basically the platform, a free platform set up by central government for local government to use to send out digital newsletters to our residents. They can choose what type of updates they would like to receive, what's going on in their borough, specifically targeting certain useful information that they're wanting to be kept up to date on, and we can deliver that straight to them via email or SMS message. And we're also undertaking a review of home alarm services to see if we can improve that with regards to different technologies. Technology is changing every 6 months, and there may be a newer, better way, more digital way of provisioning and setting up home alarms, and also looking for new partnerships as well, working with other suppliers or other councils in which to deliver a more efficient, more effective service. So from all of this, we recommend that the current proposed activity for the Digital by Design programme is that if you have any additional opportunities that would like us to explore, we can include, and if there are any identified areas that our customers would like to deliver on, or any further scrutiny that you'd like to provide. Thank you for your time.
Great. Well, thank you to both of you very much indeed. Very interesting. And it just shows how much can be done to change with the times, if you like. And I'm sure that this COVID crisis, like any time of war, it tends to increase people's innovation, doesn't it? And you have to think differently and think of very quickly of different ways of doing things. So I'm sure that you've done a great job in achieving that. Just on the hybrid meetings, it does bring to mind, would a good example of that then be, for instance, a planning meeting could take place whereby maybe the chairman and the officers or the committee as well were in the council chamber, but perhaps ward members and public speakers, formally invited public speakers, could actually join the meeting from their homes without having the need to come in and wait for 3 hours for their planning application to come up the agenda. Is that an example? Have I got that?
Yes, that's a good example. That's exactly what the hybrid virtual meeting will allow us to do. And it will also give us the flexibility to host these meetings via Zoom as the platform that we're using today, but also Microsoft Teams is another platform that we're using as well in the organization. So it has a lot of flexibility in there, and it does give us that opportunity to invite members of the public, either on the premises, but if they're still self-isolating through health issues or can't get access to the building, then they can join remotely, and it will connect the two environments together.
Well, yes, I mean, that does introduce quite considerable flexibility then, and I would imagine that's very much to be welcomed. Just on the customer service side, I just wondered, and this comes under the realms of additional opportunities for officers to explore. I suppose it's expanding on what you're already doing, really, Shirley, but a lot of people still want to be or like to be face-to-face, but obviously with COVID constraints, they don't want to be. I just wondered if maybe that face-to-face could actually be achieved by, rather than being on email or on the website or on the phone, that you have almost like a one-to-one Zoom or FaceTime, so that somebody is virtually coming into your customer service centre rather than physically, but you're still getting that face-to-face reaction and body language, and you're actually talking to somebody who can see you rather than at the end of a phone. Is that something that could be explored?
We're absolutely going to explore all of that, because I think it is timely that we start to have a look at how we can interact with those people who aren't going to want to come in and see us again. So yes, absolutely. And Zoom is a really simple piece of technology that most people would be able to use, we think. So yes, definitely going to be exploring it.
I suppose you had the option of Zoom or FaceTime or or whatever, two or three options that people may be familiar with, perhaps.
Yes, absolutely.
Great. Okay, Councillor Brennan.
Thank you, Chairman. Just very briefly, firstly, I'm very impressed, Councillor Clark, with your knowledge of these new technologies. Maybe I'll get you on Facebook. Maybe you'll be able to post some stuff on our Facebook page.
I bluff my way through these things, you know that.
I'm impressed. I've got some more general comments, but I'll save those till I've heard what other people have got to say. But Greg, can I just ask a question, please? I'm really interested in these hybrid meetings, and I think it's the way forward. And people will have heard me say this, but I get so much positive feedback about the fact that people can join from home. The access, the transparency for democracy, I can't praise it enough. I know there's still a loss of not having personal contact, and I appreciate that there's still a space for that and a need for that. But so many people have welcomed the opportunity to either watch from home or to watch later. So if we have these hybrid arrangements, this is just a bit of a technical question because I don't know, is it then possible to also broadcast those hybrid meetings on YouTube so people can watch a hybrid meeting after the event as well? Is that something
so that's definitely one of the challenges we've taken on board, and the technology that we're introducing, that is definitely an outcome that we are expecting from this solution, so that we are able to operate just as we've been operating during COVID in terms of using Microsoft Teams or Zoom and streaming that live through to YouTube. But the only difference is we'll be able to have people on premise and remote at the same time and still have the same functionality.
I think this has got big implications for local engagement in the democratic process. I think it's great. I've heard so much positive feedback from people who are happy to sit at home with their gin and tonic or whatever and watch it on YouTube, who would not come out at 7 o'clock at night to the arena, or can't physically come out at 7 o'clock at night to the arena. So I think it's great. I really welcome that. And the more innovative we can be and leading edge in this we can be, I think it's welcome.
I would prefer that people did not have a gin and tonic prior to them contributing to the meetings.
No, I meant people watching from home, Councillor.
Councillor Verdi.
Thank you, Chair. Just picking up on Councillor Brennan's point there, obviously lots of innovative ideas coming up, and engagement is going to be a very exciting, I think, opportunity in terms of moving forward. But in terms of those developments, I suppose my question centres around, and this is probably for Greg, what are the security implications in terms of data protection, security, confidentiality, and so on? If we have increases in engagement in this way, then I think that must be something which has to be a priority. I'm sure you're looking at it, Greg, but really just seeking your views in terms of how we will address that, and what sort of processes are in place to ensure that we can maintain the integrity of these engagements.
And that's a very good question, and that's why it's at the very heart of our strategy, digital strategy, in terms of security and privacy by design. It's not an afterthought. It's actually during the design of the solution that we're putting in, we will make sure that we review what the security implications are, what the privacy implications are, and ensuring that everything is secured and made private before launching or going live with any particular solution. And even right at the very beginning, when we're reviewing these systems, it's the first thing that you look at in terms of, well, is it secure? Is it You know, are they storing data? Is it in the UK? Is it encrypted? Are we making sure if there's privacy issues that we're making it clear and transparent to residents of what information has been available, shared, not shared, that kind of thing. So it is very much at the heart of each initiative that we launch digitally. It's the same principle of when COVID-19 hit. We had to make a choice in terms of the different platforms that we use around Zoom or Microsoft Teams. And it was decided based on the review that Zoom wasn't secure enough for us to have confidential meetings, so it will not be used for that sense, but it will be used in these sorts of forums, and that Microsoft Teams will be used for internal and confidential meetings. So again, that wasn't made available until those decisions and that review was made before going live.
Okay, does that, Councillor Verdi?
Yes, thank you, Chair. Greg, that is obviously, you know, it goes without saying. I'm sure you are going through those processes, and I think I'm just concerned, I suppose, in terms of, as we all are, no doubt, in terms of any breaches and the the can of worms that will open up if somebody's confidential details are over the networks revealed somehow. So thank you for that assurance, and I'm sure we'll be doing that. But yes, that's fine. Thank you, Chair.
I think one of the useful things to know is as the ICT manager, I'm also the Chief Information Officer and Data Protection Officer as well. So it's very much at the forefront of my mind when these systems go in and ensuring that we are meeting those criteria.
Yeah, thank you. Councillor Stockwood. I've got you, Councillor Thomas.
Thank you very much, Mr. Chair. Clearly, there's two aspects to the report, and I've got questions on, I think, both aspects. With regards to customer services, I think in recent times, my understanding there was a period of time when hospitals were concerned that people were so scared of going to the hospital regarding the pandemic that was in progress, that people with very serious illnesses and concerns weren't seeking the help that they needed. You touched on the idea that you would be doing more. You would be looking at how to contact people who have stopped contacting the customer service facilities, but and you've talked to and then the report provides some details of the people who are still coming in because they need to see a document. So I'm particularly interested to hear about. Are we seeing that, what kind of issues have stopped being reported to customer services? And how are we going to be sure that we're reaching out to all of the community to say there are safe and secure ways to communicate with us to make sure that those issues are, which may be of high concern, are brought forward to us, and that they know that we have safe ways for them to communicate. That was the customer services part. The digital by design part, although it's sometimes focused on the council's services, there's also a bit about energy there as well. So I'm going to stretch it out back to the previous report because Mr. Pegram's still listening in to us, and say that, within that, within the planning consultation from government, there is a talk about that in future planning systems will need to support open data standards and the publication of open data sets through the government, so that there is a standard way of putting forward data sets across the planning system, both in terms of things like the green belt, planning current applications as such. Now, I happen to know that there are some open data sets available from the Borough Council. They are through departmental, so I know that there's the green belt definition I can get if I contact the right people to include in some GIS software. But if I look at something like Ashfield District Council, I can see that they've got a page where they are actively promoting open data, and they're being proactive in sharing information on these data sets to their residents. And they have a long list of data sets available, and they're all coming through from the gov.uk portal as well. So there seems to be a direction of travel that we towards, instead of departmental pieces of software which have their own ways of presenting data, that the government wants us to move towards more open data sets with proper recognised standards, which can be seen from each council, and we can have the planning document talks about how that will help innovation within the prop tech industries, but there are a wide range of other uses for open data that can drive innovation and the recovery of the economy, and also inform residents proactively, so that they don't have to keep, so that they can find out information for themselves. So with regards to my 2 points then are, one about customer services and reaching people who have been lost to us through fear, and whether or not we're able to reach them and tell them that there are safe ways to talk to us, and particularly the kind of queries that have been lost. And the second one with regards to digital transformation, about the direction of travel that's been communicated in that planning document about towards open data sets and sharing information, all councils sharing information in a standard way, more and more, so that this can help drive the digital economy and keeping customers informed. Thank you.
Okay, so thank you, Councillor Stockwood. I'll take the customer service one, obviously, first of all, if that's okay with you. Because we managed to keep open the telephone service and obviously the emails through lockdown, as far as we, aware, we carried on business as normal. It was just the face-to-face element that disappeared. Anybody that called us or contacted us that needed to see us, or that we found an alternative way, and if that was to produce some documents or something that they needed to submit as evidence, generally they posted them in, which is, an alternative way of doing it. So we saw an increase in post coming in, which, obviously we don't want to put that additional cost on our residents. So we want to go back to either more electronic ways of doing that or enabling them to come in and see us. But we had not one complaint and not one query from customers querying why they weren't able to actually come in and see us. I think we were able successfully to enable them to do their business through all of the other methods. Greg, or Andrew, I'll hand over to you for the other response.
I think I'll just add to that as well, that the heart of the digital strategy as well isn't about necessarily replacing face-to-face or any other types of services that are not digital with digital. So it's about making it open for all channel access points. I just thought I'd mention that just in case that was a concern as well, is that if our digital transformation starts to dominate over face-to-face or any other types, that would then exclude other people who can't necessarily access services digitally. To answer your question around open data, I'm not sure if I should answer that or Andrew. I'll leave that one open. But in terms of the digital side of things, open data is very much something that is part of being digital, and if you can get data sets from other sources, to combine and look for ways of improvement and look for other digital services that may come from that, that is something that we are open to and looking for opportunities as well. There may be also partnerships with local authorities who have already gone down a particular route, so we're not reinventing the wheel, and they may have some data sets that we can share with each other. So those are always good opportunities that we can look for when going into these sorts of different initiatives. I can't answer the question specifically around planning though. I don't know if Andrew would like to contribute to that at all, or whether or not that alone answers your question.
I think probably that can be included in the general organisation of like the hybrids and so on that we've been talking about. So I'm sure that can be part of that conversation. Councillor Thomas, I think, did we lose you? Are you back again with us now? Or I think we lost you at one point. Are you back with us? We haven't got your picture.
I can hear you. Can you hear me?
Yes, we can hear you. So far away.
I can see some of you. I've got a list of issues and questions and so on from Councillor Way here, and she's very much echoing the comments that Councillor Brennan made about the benefits of being able to have all the meetings online. So, you know, that's come back from her as well. And she's also very pleased about the startup of the service in Eastleigh, and looking forward to seeing how that's happened. And I thought I'd just share with this comment with you that says chatbot sounds horrendous. So I don't know quite what that is, but she obviously wasn't very impressed with that one, or the idea of it. I've got some kind of random questions, really. Have you got figures for the percentage of inquiries that are being handled at first contact? I might have missed that in the report. Is that something we have?
We do that, and we report on it, and I can share that with you. Yeah, that's not a problem. I haven't got it with me now, obviously, but I can do.
No. I think that's useful to track going forward.
Yeah.
What is proof of life was the next question.
Okay, this is a nice to do service, actually. It used to be the borough solicitor that did it, where somebody for proof of pension needed to prove that they were alive and had to see somebody to do that. But we've been able to do it at customer services for the last 3 or 4 years.
Okay, we're quite interested in that one.
Yeah.
I was wondering, you know, talking about the different partners, is there a tourist in...
Oh,
hello.
We've just lost you again. We're frozen. I blame IT. I blame
it's these late night meetings. You know, everyone's using their internet. It's been saturated.
Yeah, I think we need a full scrutiny of Mr. Dwyer and the way he provides these services.
This is prime time. We're on peak time at the minute.
Embarrassing. Councillor Thomas, I'm afraid if you can hear us, we appear to have lost you. Your picture is frozen. I think whilst we see if you come back again, let's move on. I think Councillor Cotty had indicated or put his hand up. Councillor Cotty.
Yeah, thank you, Chairman. Yes, I'd like to make a few comments. I was lucky enough to be appointed by you in 2015 as a cabinet member for a couple of years, which I thoroughly enjoyed. And I have to say, I didn't have a lot to do under my portfolio with the customer service centre, because I'm going to make a very modest comment, but it was run well. And
we'll have to cut
out,
that.
I know, and the feedback from residents that I spoke to out of the customer service centre told me how well they were happy with the service. So I'm sure only 98% of customer service satisfaction is very disappointing for the officers. They may wish to get to 100%, but I do appreciate over the last few years the work that's gone into the customer service centre and the way we deal with people in the community of Rushcliffe, wherever they may be. I'm all for modern technology, even though I can't use it or I struggle with it. But I do get there. And I know the comments that were made about formal meetings online, which is great, and I don't have a problem once I get into them. But the thing for me is that, and also people who are working with IT all day long, today was an example where I've had 6 meetings online, and this is my 7th. And I'm absolutely knick-knacked, if you'll pardon the expression. And my last meeting finished at 6 o'clock, and I would have got in the car and driven to Rushcliffe to join the online meeting at Rushcliffe, because it got me out of the house for a bit and a bit of a change of atmosphere. So even if we do go to these meetings all the time, I would, with the workload I have, would enjoy the fact that I could have a short drive. That's probably not environmentally friendly, but at least it would save some sanity when a week gets towards the end and you've had more and more.
Oh, it's health and well-being then, isn't it?
It is, yes, it is. The other thing is that I don't think I have to declare an interest, but one of the joys of my job is that I am chairman of Inspire. And I would say, hands down, well done, Rushcliffe, because what we deliver in those 2 libraries that are mentioned for our communities with Rushcliffe Borough Council are brilliant. And Rushcliffe have always been forthcoming in that sort of thing. And it's something that really works well. We must not forget, and we don't, because the statistics have been shown is those people who can't do the online stuff. Those options are still there for them to be able to do it. So I'm in general support of an excellent report on a department that's looking to move forward again in the future to provide even better online support, but making sure that nobody's missed out. So those are my comments on the paper tonight. Thank you.
Great. Thank you very much indeed for that. Mr. Dwyer, can we just clarify that basically with the hybrid and what you described earlier, and we touched on, is it basically going to be almost like webcasting in effect, and where it comes to making sure it's transmitted in full to anybody who wishes to watch it? I'm not really talking about the participants, I'm talking about people viewing the meeting, like, and I'm going to say almost like in the old days, because it was only a few years ago, prior COVID, prior Zoom, prior Teams, we were talking about webcasting, weren't we? So is this, the hybrid, then going to incorporate pretty much that by default, really?
Yeah, I mean, that pretty much is another way of describing what we'll be trying to achieve. And if your question was how you're going to be viewing that at the arena, so if you sat at the arena in the council chamber and how you would interact with people remote, you would see those remote people on a screen on one of the big projectors, and they would obviously see you interacting in the meeting room. With the camera and the technology that we've chosen, it will zoom right into people speaking on the microphone, so you'll be able to see who is speaking, and then it will default back to a default view, most likely the front panel, the chair, until someone else then speaks within the meeting. So it'll have that level of interaction for people remote, who will just look at a screen like we're looking at right now, and one of the windows will be in the council chamber, and then for people in the council chamber, they'll be able to see everyone who's remote on a projector screen. So that interaction will be there between the two. And then the webcasting element is that we'll be recording that via YouTube to stream that out live, or if it's not a live event, we could still record it and then put it on our channel, post it at a later date.
Fine. Yeah, actually, Councillor Cottage raised a serious point, which, and Zoom, Teams, whatever, is very good and very efficient, but there is that other issue, if you, and I've experienced it as well, by having lots of meetings in one day, you have to really focus on the screen all the time, rather than being in a physical meeting where if you sort of lean back for a while, or maybe just look away, and it doesn't matter. But you have to be focused on the screen all the time. There could be possibly an issue as regards health and well-being. I don't know how, I suppose this is more a personnel matter really, as to how you actually guard against ending up with a headache.
Yeah, I mean, it may be something to consider moving forward with hybrid meetings, is that generally the general rule of thumb should be, not that we've necessarily followed that this evening, is that every hour we should at least have a 5-minute break. But it could be something that you introduce in these hybrid meetings, where the people who are remote can have those 5-minute breaks, then come back again. Don't know how practical that might be, but it would be something that would need to be considered around that, because I know what everyone is saying. I sympathise entirely. In my world, especially when COVID hit, I just spent near enough, it felt 24 hours staring at a screen off one meeting to the next, to the next, to the next, and they're all very much video conferencing. So it does get very tiresome.
Yes, and you're right. Thank you for politely smacking me on the wrist. Yes, we should have had a break, but I realise it's gone 9:15, and I realise time is getting on. Councillor Thomas has rejoined us. I just wondered whether could you just sort of maybe quickly put your points, Councillor Thomas, and we really need to think about probably wrapping it up. But Councillor Thomas.
I don't know quite where I cut out, but I was asking if we had considered partnering with some sort of tourist information service to provide a tourist information service from the contact centres.
We already work in partnership with Nottinghamshire County Council, who offer the tourism service. So we can link into that. If we had anybody that needed any support in that, we would be able to give that advice through them straight away.
Okay, thank you.
No problem.
Okay. Right, Mr. Mitchell.
If I can, thank you very much, Chairman. If I could bring us back to the recommendations in the report, I think tonight on this item you have reviewed the activity of both customer services and digital by design, and you have identified some additional areas. What I perceive is more information. I don't think necessarily you've identified something to come back, but I think some of the things that I picked up were moving more to face-to-face, Zoom type conferencing. Indeed, we introduced that in Italy 10 years ago. We were one of the early ones and it never worked. But I think now is the time. Innovation has taken up. Hybrid meetings, I think there's a bit about what we want to do and what we're allowed to do. And I think we will require some government legislation to do public meetings in hybrid, which may be forthcoming in the near future. It's moving at a pace. But certainly more advice and guidance on how they operate. Councillor Stockwood mentioned about confidentiality of data and open data, and I think that's one that we can come back to with what data we would look to put online. And then finally, Councillor Thomas raised first contact information and how many we resolve at first contact. Now, I perceive those under recommendation 2 could be done by a quick briefing note out to members to cover those items if you're happy with that. Thank you very much.
Yeah, I think that seems reasonable. Is everybody happy with those summarising comments? Everybody happy that we proceed on that basis? So yeah, that's helpful, and look forward to seeing sort of further improvements, and hopefully our customers will maybe get up to 99% or even 99.9%. Who knows? The pressure's on, Shirley. The pressure's on. Anyway, thank you to both Greg Dwyer and Shirley Waltman for waiting for so long. I apologise for keeping you so late, but one item had to be first and the other item had to be second. So I apologise for that, but thank you for your perseverance, and we'll let you get some rest now. So thanks for that. And moving quickly on just to the final item, which is the work programme, which I suspect and hope will not be very long. I don't know, Mr. Mitchell, are you wanting to?
Only to I think there's some things missing off the programme. So if I could work through the next 3 meetings and look at 14th of October, we have got Abbey Road developer coming to you, and the planning enforcement coming back. There is an additional item that is required from council in relation to the crematorium, and we would look to bring an item to satisfy that council recommendation to the Growth Scrutiny Group at the 14th of October.
Crikey, that is going to be a pretty packed meeting again then, isn't it?
I don't think it's a decision point, it's just really a discussion point. I hope it's possible. Indeed, planning enforcement, I would hope, is a fairly short meeting after tonight's longer discussion where you're just looking at the policy that we can then move on. So we'll work on that, but with breaks, as Greg said, it would be quite well done. The 20th of January, there is a missing item in there, and that is the open spaces to come back. And we're doing the work behind the scenes on the open spaces. And that will bring, we'll shortly be writing out to members. We identified 29 sites that have got open space management companies, and we tried to summarise what's happening on those sites at that meeting. And in addition to that, I think we got cashless. Now, in the summary right at the top, you'll see that Council Way identified cashless, and we said we'd wait until hopefully after the pandemic's hit to see, bringing you some information about the impact on people's ability to access cash and use cash back in January. Now, the final one that I am reminded about, just on the planning enforcement part 2, there were recommendations in that report that we discussed a while back. And I'm presuming you have agreed those recommendations, and we will bring back the information that I summarised at the end of that meeting if you're happy with that.
Yeah, and we can discuss any final tweaks to the policy if anybody wishes to propose anything else. Yeah, sure. Okay, is that cashless, the cash machine, is that going to come on to put onto April then, is it?
I think we can fit that into the January meeting, but if not, that will be one that would move April. It depends on the impact of this pandemic as we go forward.
Right, okay. Everybody happy with that? Any questions, comments? No, great. Lovely. Okay, thanks very much indeed. Thank you very much for everybody's perseverance and sticking with it. It's just the very first item wasn't a convenient place to have a break, really, in the first item, which took the longest. But anyway, thank you very much for your energy, and we'll let you now have a rest. So thanks to all the officers for their presentations, and thank you to you members for all your contributions. And I'll declare the meeting closed and wish you a very good evening.